Hearing in the appeal, Canada Square Operations Limited against Potter.
Before we begin, there's one housekeeping matter that I should mention. Three of us, before we came on the bench to deal with this hearing, were dealing with an application for permission to appeal in the Rwanda affair, and we are going to have to adjourn at some point to finish dealing with that once we've had a response to an inquiry that we've made. So probably that'll be around 11 o'clock. I'll get an email to tell me when we can finish dealing with it. So just to forewarn you, there's liable to be that interruption at some point. So, Mr. Kimmins.
My Lords, I appear for the appellant CSO in this matter alongside Sean Snook and Fiona Whiteside. And my learned friend, Mr. Robert Weir, QC, appears for the respondent alongside Jonathan Butters, and I'll refer to the respondent as the claimant. My Lords, my plan is as follows. I'm planning to speak until 3 p.m., subject to Rwanda, of course, and I'm intending to structure my submissions as follows. Some brief introductory remarks. I'll then try and summarize CSO's case on this appeal in a nutshell, and then consider the basic purpose and structure of Section 32, then focus on the issues arising under Section 32.2, and then the issues arising under Section 32.1b. That's the plan, obviously subject to any thoughts your lordships may have as to the order in which you wish to hear submissions.
Yep.
By way of brief introductory remarks...
Actually, one other matter, while it is in my mind, just to mention to you, we have all been over this territory already, as you know, in the Primeo case, so you can bear that in mind in going through the authorities. I'm not trying to hurry you up, but just to let you know that we have been through them all once before, so you can take it we don't need to have everything explained to us.
My Lord, I'm very grateful, and if I'm being repetitive, either repetitive or boring, please say, and I will move on very quickly. But a brief introduction in relation to the parties. CSO is a Citigroup entity. CSO was formerly known as Egg Banking PLC. Egg was known as the first internet bank, and the claimant is a test claimant. CSO understands the claim is funded by Spectra Legal Finance, which is a specialist litigation funder, has funded over 50,000 Plevin claims, and you'll all be very familiar with Plevin claims. As the court knows, the claim is based on the non-disclosure by the appellant of commission received by it relating to a PPI policy, and the appeal relates to the meaning and application of various provisions of Section 32. Before summarizing our case as succinctly as I can, if I could just make some brief comments on the facts, and just to remind your lordships of the timeline, which is relevant to some of the concessions made by my learned friend and to some of my learned friend's new arguments. The credit agreement that we're concerned with was concluded in July 2006 between the claimant and Egg, the predecessor to CSO. Section 140A to 140C of the Consumer Credit Act 1974 were inserted on the 6th of April 2007, so nearly a year later. But as far as this agreement in this case is concerned, those provisions came into effect from the 6th of April 2008, so a little later, albeit when those provisions were brought into effect, they were brought into effect retrospectively. So from April 2008 onwards, a court could in principle determine that the relationship between a creditor and a debtor was unfair within the meaning of that provision, with the result that the court had the power to make various orders. Now, the relationship came to an end on the 8th of March 2010. At that point, everything is paid off. And throughout that period, of course, and this is common ground, and indeed after the credit relationship had come to an end, there was no regulatory rule requiring CSO to disclose the commission. And indeed, as the Court of Appeal noted in various paragraphs, the FCA had indeed said that there were downsides to requiring disclosure. including customer confusion and potential information overload. Nonetheless, the Court of Appeal found that there were, and I quote, warning signs of unfairness before March 2010. And so it was on that basis that they found that CSO knew there was a risk that the relationship was unfair under Section 140A, effectively at some point between April 2008, when the retrospective provisions came into effect for this particular agreement, and March 2010, when the relationship came to an end. Now, it was over a year later, in October 2011, that you get the first material judgment on Plevin-type claims, and that was the Court of Appeal's judgment in Harrison and Black Horse. And they found, of course, that the failure to disclose commission, almost identical facts, did not give rise to an unfair relationship. And you have a judgment of Lord Justice Tomlinson, Lord Neuberger, and Lord Justice Patten. That's obviously significant. And it was only in November 2014 that judgment was handed down in the Plevin case when Harrison was overruled. And it was there that Lord Sumption said a failure to disclose the commission of that magnitude did render the relationship unfair. But the rationale, of course, of the Court of Appeal earlier in Harrison and Black Horse was that the ISOB, I'm going to call them the ISOB rules, I've no doubt pronounced that wrong, the ISOB rules did not require disclosure, and therefore in those circumstances, ex hypothesi, they could not give rise to an unfair relationship. And Lord Justice Tomlinson and the other members of the Court of Appeal no doubt had in mind, of course, that the ISOB rules, and I quote from a judgment of Mr. Justice Hamblin in 2009, might be said to be a high target by which to set a standard and were based on existing industry standards and practice. But, my lords, the reason I'm going through all of this is to give you the background to a concession made by my learned friend, which is of importance in this case. And it may be worth just turning that up very briefly. It's recorded in the Court of Appeal's judgment at paragraph 86, which is at page 194 of your Lordship's electronic bundle. And at page 194, you'll see the Court of Appeal dealing with the meaning of deliberate. And they set the scene in 85, and then in 86, they say there are 4 candidates for the mental element needed. The most stringent test would be if Mrs. Potter has to show subjective knowledge or actual awareness within Canada Square that they were committing a wrongful act, either in the breach of duty, that's 32.2, or the concealment, that's 32.1b. Mr. Weir, appearing for Mrs. Potter, accepts that Mrs. Potter cannot establish actual knowledge for either Section 32.2 or 32.1b, so that Canada Square's appeal must succeed if that is the test. The second potential test is subjective knowledge, which includes willful blindness. Again, Mr. Weir accepts that Mrs. Potter cannot establish deliberateness, even if willful blindness is included in knowledge. And then after that, the court goes on to consider recklessness. And that gives you the background to what, in effect, we're arguing about. The key issue, really, we say before your lordships, is whether it is right, as the Court of Appeal found, that recklessness is sufficient. Because if it is, obviously I lose. If it isn't, I say I win. And that's, in some ways, the short answer. My lords, having made those introductory remarks, if I could just set out our case on this appeal in a nutshell. Starting with Section 32.2. That raises the simple issue as to whether the word deliberate in the phrase deliberate commission of a breach of duty includes recklessness. We say no. My learned friend says yes. The Court of Appeal found yes. Just to unpick the Court of Appeal's reasoning a little, one can see from the judgment that they considered essentially 4 points. And we say they got each and every one of them wrong. The first was language. And the Court of Appeal said there is no obvious natural meaning to the word deliberate. And we respectfully disagree. We say it's very straightforward what that word means. But they needed to make that finding in order to delve into the legislative history, etc. So language is the first point. Authorities is the second. And the Court of Appeal said that the authorities on this point were unclear. We say, again, that's wrong. And they are clear on the point. And in particular, CAVE is clear on the point. And I'll take you to various provisions in that case, conscious, of course, that you have been dragged through that case previously not long ago. Yeah, you then have the parliamentary objective, and I'll make a few remarks on that. The Court of Appeal considered that my learned friend's case better met that, and again, we take that head on, and we say, no, that's not right. And then finally, the key part of the Court of Appeal's rationale was based on the old cases. And if one looks at page 210 of the bundle in front of you, you'll see conclusion, this is at page 137, conclusion on the meaning of deliberate. And this is really the Court of Appeal's key rationale. My conclusion, I'm on page 210, my conclusion following this survey is therefore that the pre-1980 case law established that recklessness was a sufficient mental element for the old Section 26, and the parliamentary materials relied on by Mrs. Potter show that the test under Section 32 was not intended to be any more difficult for the claimant to overcome. Expressed in modern terms, and so they go on. But what one can see immediately that in effect, the key rationale was reliance on those old cases, and we say the Court of Appeal took a wrong turn there and should never have engaged in those old cases for reasons which I'll come on to explain. But we say essentially we're right on language, authorities, purpose, and old legislative materials. If we're right on that, that should and would have been the end of it. But my learned friend has raised a new argument, which we deal with in our additional submissions, a fallback argument. And my learned friend's very candid about that and says, I only run this if I'm wrong on recklessness. So it's slightly result-driven. But in those circumstances, what we say happens is my learned friend seeks to repackage a very similar test to the recklessness test, but without using the word risk as much as he can in order to distance himself from a recklessness argument. But we say it simply doesn't help my learned friend. He cannot get away from the fact that you need to know that what you are doing is a breach of duty. And that's the short answer to both the case as originally put and my learned friend's new argument. Now, that is our case in a nutshell on 32.2. On 32.1b, we move on to deliberate concealment. And of course, that point only arises on the hypothesis that the word deliberate does not cover recklessness. If it does cover recklessness, then I've lost already on 32.2. But if it doesn't, as we say it doesn't, one then comes on to 32.1b. And we say that there is one key issue which arises. Does there need to be a legal duty to speak, or does a duty based on, and I quote, a combination of utility and morality suffice? And we say funnily enough, the Supreme Court website puts this very pithily in summarizing the issues in this case. It says there are two. One is the meaning of the word reckless, and two is the meaning of the word conceal, and whether you need a legal duty. And my lords, we say that's absolutely right. It's pretty much as simple as that. As to the legal duty, our case in a nutshell is this, that there is a decision of the Critti Palm, in the Critti Palm of the Court of Appeal, which is, we say, very clear that a legal duty is required. And we confess, my lords, to being slightly taken aback and surprised at the Court of Appeal's judgment on the Critti Palm, in that we do say, and I will take you to it, that if one reads the Critti Palm, it is quite plain that it was referring to a legal duty, and that the Court of Appeal read far too much into the dicta of Lord Justice Buxton in that particular case in saying that something less sufficed. We also say our case is more consistent with the purpose of Section 32, not least on grounds of certainty, in that it's difficult enough to assess whether one is under a moral duty even more difficult perhaps to assess whether one is under a duty as a matter of utilitarianism, and the combination becomes even more elusive. And of course, that's the basis of the finding, that it is a duty based on a combination of utility and morality. Now, one also has to bear in mind the fact that the Court of Appeal applied a recklessness test to the utilitarian moral duty. And so one ends up with an extraordinarily far-reaching test under 32(1)b. On the Court of Appeal's analysis, the question is this: did CSO know of the risk that it was under a moral utilitarian duty to disclose the commission? And they found that CSO did know of that risk. And we say the Court of Appeal was wrong on both fronts. One, it shouldn't be recklessness. And two, it shouldn't be a moral utilitarian duty in any event. It must be a legal duty. But it is worth pausing to think of the how far-reaching that Court of Appeal finding is. Because I confess that almost every day I might feel I am under a moral, or that there is a risk, I should add, that I am under a moral utilitarian duty to disclose something to somebody. And in commerce, every day, people negotiate contracts. And there is an age-old tenet of contract law, caveat emptor: you do not have to disclose things, subject, obviously, to being under an express legal duty to do so. You can't obviously mislead, and I'll come back to this point. But this is fundamental stuff. And if one looks at the Court of Appeal's ruling on its face, if you know that there is a risk that you are under a utilitarian moral duty to disclose something, you're guilty of deliberate concealment and you lose the advantage of the Limitation Acts. And we say that in many cases of contractual negotiations, you know that your counterparty might be interested to know X or Y, but you also know that you are under no duty to say X or Y. If the buyer or acquiring party wishes to include warranties in a contract of sale, so be it. It may do so. But that is a fundamental right of silence. And Lord Justice Ricks, in a case I recalled it, used the phrase, silence is golden. And that's an important tenet of English law. And we say this makes inroads into that, because anybody well advised at the time they're conducting contractual negotiations might start thinking to themselves, well, there is a risk I'm under a moral or utilitarian duty to say X. And if I don't say X, I lose my limitation privilege. And it's an incredibly important privilege for reasons I'll come on to touch on. So we do say that it goes much too far. And of course, one also has to remember the breadth of 32(1)b in any event, which is a consequence of the Sheldon case. And this is an important point, because 32(1)b is an extraordinarily powerful weapon. Because what it does, it enables you to reset the clock to 0, even if the clock has been ticking for a certain period of time. So your cause of action accrues, limitation is counting against you for, say, 4 years. At that point, if you're guilty of deliberate concealment, the clock goes back to 0. You're back to naught. And that's what Sheldon found. And of course, that case has now been taken to its natural logical conclusion by Mr. Justice Fraser in the AG Alliance case. And that even if the deliberate concealment postdates the expiration of the limitation period, it still sets it back to 0. And that is why it is such a powerful weapon. So you could be 10 years after concluding a contract, you could discover something. You could think to yourself, I am under, there is, not even I'm under, there is a risk that I am under a utilitarian stroke moral duty to say something. And if I don't say that, it may be 10 years after the contract, 10 years after the cause of action accrued, but if I don't say it, I'm guilty of deliberate concealment, the clock goes back to 0, and there's a claim against me. And so we do say that if one puts these bits of the jigsaw together, including the real power behind 32(1)b, and that is important, this is an extraordinarily far-reaching judgment of the Court of Appeal, and we say that they have taken a wrong turn there. If we're right that a legal duty is required, then we say the appeal should be allowed, and that is because recklessness is not sufficient, and we would have already got home on that in order for this issue to arise at all, because we would have won, I hope, on the meaning of deliberate in 32.2. It's common ground that deliberate means the same thing in both sections. There is also an issue in the background, assuming that one needs to show a legal duty, of whether there was in fact a legal duty in this case. And I'll come on to that later, but we don't need to win on that. If we've won on the combination of a legal duty and the requirement of actual knowledge, then that's the end of 32.1b in any event. Now, I say all of this subject to one wrinkle, which is my learned friend's new case on active concealment. And I'll deal with that again when the time comes. But my learned friend takes a new point, which we say he can't take, and this is the only point we say he can't take, that there was what I'm going to call positive act concealment in this case. And I'll deal with that later, but we say too late to run it and wrong in any event. If your lordships are against me, such that a moral utilitarian duty does suffice, what happens then is my learned friend home and dry. We say, well, no, not quite. The position gets a little bit more complicated there because you have to unwrap it further and then consider the mental elements required. Because you could, for example, reach a view that you needed a moral stroke utilitarian duty, but you needed to know that you were under it, not be reckless, and you needed to know, not be reckless, that the fact was relevant to a claim against you. So those additional questions will come into play in any event on that hypothesis. But we say one never gets there because the simplest and neatest way through, and I would say that because it's in my favor, is to find that a moral utilitarian duty is not sufficient and that the word deliberate does not encompass recklessness. Now, that has been a pretty swift skip through our case in a nutshell. What I want to turn to now is the basic purpose and structure of Section 32. I'm conscious your lordships are all extremely familiar with this territory from the test claimant's case and have been dragged through the history of these acts many times, and I'm not intending to do it all over again. What I will do is just draw or remind your lordships of some of the key principles underlying limitation and exceptions. Obviously, the dicta of Lord Millet in Cave is something I rely on. The statutes of limitation have been described as statutes of peace. They're regarded as beneficial enactments and are to be construed liberally. And the themes that I've extracted from those cases, in particular the test claimant's case, are as follows. Point number one, defendants are to be spared the pain of litigating stale claims. And you get that from Lord Millet, funnily enough, citing Chief Justice Best, and I can't put it better than this: long dormant claims more often have more of cruelty than of justice in them. So the point is, the defendant should not have to deal with the claim. He shouldn't have to dig about looking for evidence to meet a claim which is that old, because it's unfair, because it's stale. The second principle one can extract from these cases is the promotion of concepts of finality, certainty, and security of settled transactions. And I use those words advisedly, and I've stolen them from the judgment of Lord Sales in the test claimant's case, who went all the way back to the statute of limitations in 1623, identifying that it was to promote finality, certainty, and security of receipt of money. And Lords Reed and Lords Hodge in the test claimants also said that regard must be had to the importance which this court attaches in any event to legal certainty and the security of settled transactions. So those are your two starting points. What do you need in order to further those purposes? Well, you need rules which are clear and certain. Otherwise,
I'm afraid, can I interrupt your rhetorical question? And we've now received the a response in relation to the Rwanda matter. And I think it'd be best if we were to adjourn and deal with that, and we can then give our undivided attention to your submissions. So we'll adjourn for, well, as long as it takes, but I don't think it will be more than, say, well, I'm not sure. We'll keep you advised via our usher as to where we are.
Very great.
Now, I must begin by apologising on behalf of the court for the disruption to today's hearing. I mean, I can very well understand how counsel and those behind you must be feeling. I'm afraid it simply couldn't be helped. We had to deal with this Rwandan business this morning. What I would suggest is that we keep an eye on what progress is being made. We have the ability to sit late if when you're going to need the time, both today and if necessary tomorrow. So shall we carry on and see what progress we make, and subject to your own availability, if you want to carry on beyond 4 o'clock this afternoon, then we can certainly do that.
I'm very grateful, my Lord. My Lord, we were looking at the purpose behind Section 32. We were looking at the purpose of limitation more generally, of sparing the pain of litigating stale claims and promoting finality and certainty.
Yep.
And the principle which facilitates those purposes is clarity and certainty. And there are many statements to that effect in the various authorities. If one goes back to Lord Sumption in 2012, in the original test claimant's case, and I quote, you needn't turn it up, but he says, in an ideal world, all rules of law would be clear. But there are a few areas where clarity is as important as it is in the law of limitation, whose whole object is to foreclose argument on what ought to be well-defined categories of ancient dispute. So there he's noting the point that everything should be as clear as...
Could you just tell us the paragraph number?
Yes, apologies. That's paragraph 185.
Thank you.
And it's at 2607 of your Lordship's electronic bundles.
Thank you.
And this need for certainty has been long recognised. Just to give you one other reference, if you could turn up 2356, you will see a page from the Law Reform Committee 21st report, which was 2001. And I needn't show you much more than the reference about a third of the way down to possible approaches. And you'll see there that what was being debated was the concealed fraud approach, date of knowledge approach, or the discretionary approach. And all three were considered.
Could you give me the page number again? I'm so sorry. Electronic page?
2356.
That's the contents page.
That's the list of contents.
Yes, it is indeed the list of contents.
Yes, so you're looking to the list.
Yes, indeed. That's exactly where I am, actually.
Okay.
Apologies. But just because it shows it quite neatly.
Yeah.
If you look at the list of contents, you'll see when it comes to possible approaches, you have three: the concealed fraud approach, the date of knowledge approach, and the discretionary approach. And the point I'm making is if one then goes into the body of the report, you will see that the majority goes for the concealed fraud approach, rejecting the others, and principally on grounds of certainty. And for your note, at 2372, paragraph 2.35, you'll see it recorded that the majority take the view that certainty is the prime consideration. Hard cases are likely to be few, and that justice to the defendant whose conduct has not in any way been unconscionable demands that he be protected once the limitation period has run. So another illustration of the importance of certainty, and indeed we see further statements to that effect in the test claimant's case in the 2020 judgments involving many of your lordships, where Lord Sales, and I quote, this is at paragraph 298, little 3, at page 805, said the Limitation Acts are statutes which have the object of producing certainty by the application of simple rules which also offer the prospect of resolution of disputes without the need for litigation. So time and again one sees the importance of certainty, because the whole idea is certainty prevents those two vices of defendants having to trawl through papers and all the rest of it in relation to age-old disputes, and for people to enjoy finality, certainty and security of settled transactions. Now that rule of certainty obviously applies to construing the limitation periods themselves, but also the exceptions. They must be equally as clear, because one has to know where one stands for this law to be effective in achieving its purpose. And so, hence, your lordships are acutely aware there was great debate of the issue of certainty in relation to 32(1)(c) in the test claimant's case. Now, there is a further and more contentious issue, which is whether Section 32 should be narrowly construed. And there is a difference of opinion on this. There is an argument that it is an exception to the general object of the Limitation Act and should be given a restrictive construction. And that was the view of Lord Sales, Lord Briggs and Lord Carnwath in the test claimant's case, and the reference is 298(2). That's the paragraph number at page 805. And there are other judges who have reached a similar view, Mr. Justice Mann, in the case of Cotonou and Reeves, and the reference there is paragraph 62 at 1717. I'm not going to turn all these up in order to try and keep moving things along relatively quickly, but please do say if you'd like me to take you to any of these particular paragraphs. Now, as to the majority in the test claimant's case, it's true to say that they did not provide any additional support for the proposition that Section 32 as a whole should be narrowly construed. But I do say, albeit with some trepidation given who's in front of me today, that at the same time they do not unequivocally dismiss any suggestion that it should be narrowly construed as being an exception to the general object of the Act. The place where the majority deals with it is at 242 brackets 10, subparagraph 10, which is at page 786 of the bundle. And you'll see that the focus for the majority was very much on Section 32(1)(c) and some dicta from the Phillips-Higgins case. And if your lordships look at paragraph 10, little 10, which should be on your screens, it can also be argued that Section 32(1)(c) should be restrictively construed consistently with dicta in Phillips-Higgins, etc. And then the majority says, well, that was dealing with a slightly different point. Nonetheless, if I distill all those various dicta, one can see that there is an argument, and we say it's the right argument, that the principal policy of the Act is to bar stale claims. Now, I don't say it's the unqualified purpose, but the principal purpose. And for that reason, one is entitled to apply the maxim of construction, that the exceptions to that principal purpose should be narrowly construed. And we pray in aid, as I say, of Lord Sales and Briggs, etc., at page 805. So, my lords, that is an open question. In truth, it is unlikely that much is going to turn on it in this particular case, but there we go. It was one of the issues identified in the list of issues before your lordships. And,
what does it add? Isn't one simply obliged to construe the words in the context of the...
My lord, we would say so, yes. It's always going to be a last resort point. We say one doesn't get anywhere close to needing it in this case because the word is so clear. The word deliberate is so clear. But I dealt with it briefly because it was identified in the list of issues in case your lordships were interested in it. But I don't think we ever get there.
Isn't the law here seeking to draw a balance between competing considerations, on the one hand preventing stale claims, on the other hand preventing fraudulent concealment?
Indeed, and there are competing considerations, and I suppose the question relates to the balance. And we say the principal object is barring stale claims, but it's not unqualified. There is a qualification. The balance, though, lies with the former, and that's why you are enabled, if you want to apply the narrow construction exception. But as I say, I genuinely don't think one will ever get there on the facts of this case. So one then turns to 32(1)(b) and 32(2). What is the policy behind those particular exceptions? And it is important not to be contaminated by dicta relating to 32(1)(c), which is a very discrete area relating to mistakes of law, which your lordships are all very familiar with. The policy behind 32(1)(b) and 32(2), we say, is essentially to punish improper conduct. And we get that from a number of different cases, including Lord Brown-Wilkinson in Sheldon, and the reference there is page 142F, which is at page 667 of your bundle. The aim is to ensure that the Act does not operate to bar the claim of a plaintiff whose ignorance of the relevant facts is due to the improper actions of the defendant. And one sees similar dicta to that effect from Lord Nichols in the same case at 153H. And that's at page 678 again. I don't think it's necessary to turn it up. Those dicta are cited with apparent approval by Mr. Justice Park in the Williams case, which you'll also be familiar with, and that's at page 812 for your note. So that is your starting point. And one also sees reference to the policy behind the Acts and the policy behind Section 32 in Cave itself. And your Lordships are very familiar with Cave. I could just take you to one short passage, which is at page 526. And your Lordships were taken to this, I think, at some length last time you heard submissions on 32.2. But if one looks at 526 and looks at paragraph 15, you'll see the point they make in relation to Brocklesby and Armitage. And about midway down paragraph 15, however stale the claim, he must defend the action on the merits, for he will not have the benefit of a limitation defence unless he can show his advice was not negligent. This subverts the whole purpose of the Limitation Acts. The harshness of the rule is evident. In the absence of any intentional wrongdoing on his part, it is neither just nor consistent with the policy of the Limitation Acts to expose a professional man to a claim for negligence long after he's retired from practice and has ceased to be covered by indemnity insurance. And then again in paragraph 17, you'll see further reference to intentional wrongdoing. So we say that the touchstone for Section 32.1b and Section 32.2 is improper conduct and intentional wrongdoing. And we say once one recognises that, then if one goes back to the concession which was made in this case, which we looked at right at the beginning in paragraph 86 of the judgment at 194, my clients did not know that what they were doing was, to quote Lady Justice Rose, a wrongful act. They did not know that they were in breach. And in those circumstances, we say you're outside of the ballpark that is contemplated by these particular provisions. As to the structure of the provisions, just a word or two on those. Sometimes it's quite difficult to link together 32.1b and 32.2, but we say they essentially, between them, cover three scenarios. Scenario 1 falls under 32.1b, and that is a case of positive act concealment. And that is where, to give you an example, a builder does a bad job resulting in cracks in the walls, and they are then covered up by a positive act of concealment. And one needs to be careful in the cases. Sometimes the word active is used rather loosely. What we're concerned with here is positive act concealment rather than active concealment, which active concealment could conceivably cover both that and something where you are under a duty to conceal. Sometimes that is described as active. But here I'm looking at positive act concealment. Secondly, under 32.1b, we say you have a failure to disclose where there is a legal duty to do so. That is the other category which falls within 32.1b and constitutes deliberate concealment. So you have a classic example is a solicitor who is negligent and who then recognizes that he is negligent a year later once he sees what's gone wrong. He is then under a duty, a legal duty, to disclose his negligence once he has become aware of it. And that is a classic, we say, 32.1b, deliberate concealment, arising out of a failure to make disclosure. You have another example in the Critty Palm, where they decided that, we say there was an implied term, that having been in breach in originally getting a sampling procedure wrong, they then discover the issue but say nothing. And those are classic examples of failure to disclose in breach of a legal duty constituting deliberate concealment under 32.1b. And so those are your two categories. You then bring into play 32.2. And the neatest way of seeing how that comes into play is to go right back to the Beeman case. If I can just show you a short passage, please, at page 5 sorry, page 490 of your bundles. And 490 of your bundles, we are in the midst of Beeman and the judgment of Lord Green. And you'll see a third of the way down, you'll see, but there may, in my opinion, and this is what introduces what is now 32.2. There may, in my opinion, be fraudulent concealment of a cause of action which is not subsequent to the act which gives rise to the cause of action. It may acquire its character as such from the very manner in which the act is performed. And then if one goes on about 10 lines and picks it up, provided an action was not based on fraud, and provided there was not any subsequent active concealment of a fraudulent nature, the wrongdoer would have obtained the benefit of the statute, however furtively or surreptitiously the act complained of was committed. The manner in which equity treated, for example, a tort surreptitiously committed when the statute of limitations was pleaded is illustrated by the case of the secret abstraction of underground minerals. And this is what we referred to before the Court of Appeal and below as a bully-type breach. In Bully, the Privy Council had to consider such a case if the appellant in that case had been merely guilty of trespass. The ordinary 6-year period would have applied, but the very manner in which the trespass was committed was a surreptitious one. And Lord James of Hereford said in delivering the judgment of the board, the contention on behalf of the appellants that a statute is a bar unless the wrongdoer is proved to have taken some active measures in order to prevent detection is opposed to common sense as well as to the principles of equity. Two men acting independently steal a neighbour's coal. One is so clumsy in his operations, or so incautious that he has to do something more in order to conceal his fraud. The other chooses his opportunity so wisely and acts so warily that he can safely calculate on not being found out for many a long day. So that was the source of 32.2. So they said, okay, you have positive act concealment, breaches of legal duties to disclose, but we need to cover the scenario where an underlying breach is sufficiently furtive, see 32.2. And that is what gave birth to 32.2. And the structure is important in some ways. For this reason, it's a point I come back to later. What happens if there is only one type of conduct that you are concerned with, which is the original breach, which happens to be a non-disclosure? Can you fail to get within 32.2? And that is the provision which focuses on the breach and the nature of the breach, and yet be saved by 32.1b in any event. And I'll come back to that later. So that is how we say the provisions fit together, and that is what we say the statutory purpose is of both the acts and the exceptions. And having said that, I'm going to move on, if I may, to the 32.2 issues. And what I would submit is the simplest issue in this case: does recklessness suffice for the purposes of a deliberate commission of a breach of duty? Now, we deal at some length in our submissions with the linguistic points, and they're relatively straightforward. We take the well-trodden path of going to a dictionary first and looking at the definition of deliberate, and I'm not going to drag your lordships through all these references. Your lordship will very much have these in mind. But a clear distinction is drawn in dictionaries and the like between deliberate conduct and reckless conduct. And it's really as simple as that. And in some ways, our submission doesn't need to go any further. As a matter of very straightforward, ordinary language, the word deliberate must mean that you know, in the context of a breach, you know that what you are doing is a breach. It's really as simple as that. If one then moves from dictionaries and looks at authorities on the meaning of the words deliberate and reckless, again you see the distinction drawn time after time. And I'm not sure I can improve, my lords, on paragraphs 78 and following of our written case. If I could take your lordships to that very briefly. It's page 78, apologies. So that's page 78 of your electronic bundles. And if I could just remind your lordships of some of the references which we've dug out. You have in paragraph 24 on page 78, Lord Justice Haddon Cave, knowingly is something different in law from recklessness, knowingly connotes something more than mere recklessness. In simple terms, one can be said to know something if one is absolutely sure that it is so. Being reckless, on the other hand, means merely taking unjustified risk. So it's this that we say forms the basis of our distinction between conscious wrongdoing and conscious risk-taking. And we say they are very different concepts. The point can be made by reference to a great many authorities. And we cite some of them on pages 79 and 80. You'll see the De Beers case on page 79. Deliberate default means, in my view, a default that is deliberate, in the sense that the person committing the relevant act knew that it was the default, in this case a breach of contract, does not extend to recklessness. Mutual energy, there's plenty of authority that the use of the word deliberate in the context of a breach or default means an intentional act. The Supreme Court of New South Wales, referring to a pleading in the UKSC reinsurance case, draws the same distinction. And then most recently, in the Burnett case, which I think Lord Reid was in as well, Lord Hamlin makes the very simple, straightforward point, and I quote, "The starting point is the natural meaning of deliberate acts. This connotes consciously performing an act, intending its consequences. It involves a different state of mind to recklessness." And we say again, this is all of a piece with what ought to be one's initial reaction when considering what a deliberate breach of duty means. We say it's very straightforward. We also add, it's no answer to say that these are phrases which appear in contracts and therefore they can all be discarded. We say no. One has to have a reasoned explanation of why the particular construction enables you to jettison that particular meaning. But also, a lot of these dicta is wider than that and simply says the natural meaning of the word is this. So the judges, when faced with these words in contracts, give them the natural meaning. And therefore, we do say they are of significance. On top of that, you have a number of statutes which draw a careful distinction between deliberate and recklessness as a matter of language. We also refer to that in our written case, and I'm not going to take you to those, but there are a number of them. And if one then considers, well, where is the authority on the other side of the equation? Where are the cases which say, deliberate can sometimes mean reckless? And there are none, we say. And this was a factor which was expressly recognised as relevant in the Burnett case, where Lord Hamlin said, counsel for the insurers has not been able to show us any case in which deliberate has been held to include recklessness. And he then continues and makes the additional point, and his language is interesting. If exceptionally, if not uniquely, deliberate was intended to include recklessness, he says, he then goes on to say what one would expect there to be an explanation of what recklessness meant in any particular context, given the fact that recklessness is a very multifaceted concept which is difficult to define. So one has a scenario where one has dictionary definition which favours recklessness not qualified. Authority after authority to the same effect. Distinctions drawn between knowledge and recklessness in statutes. And no authorities pointing the other way. The high point of my learned friend on authorities is two old cases on 32.2, i.e. the very wording. There's one called Westlake and one called Ramsden. We deal with them in our written case, which suggests the contrary. But that's as far as one goes, and we explain why they don't really assist at length in our written document. So you have a very strong body of authority to the effect that deliberate cannot include recklessness in that particular context. Now, that's language. If one then moves on to authorities, and I'm conscious that you've been taken to Cave before, and I don't want to repeat points which you've already heard, but the one point I do want to make on Cave is this. There was lengthy discussion, clearly, on the issue of recklessness in this case. Cave has been dismissed as a case which had nothing to do with recklessness because it said the contest was between actual knowledge and negligence, inadvertence, and nothing in between. But that's not right, because there was significant argument on where recklessness comes And I think the easiest way to see that is to look, first of all, please, at page 526 of your bundle. And we're in the midst of Cave, and if one looks at paragraph 17, I touched on it a minute ago in relation to the words intentional wrongdoing, but what paragraph 17 does is show you what the contest was in Cave. The question is whether the words deliberate commission of a breach of duty in section 32(2) of the 1980 Act mean deliberate commission of an act or omission, being an act or omission which gives rise to a breach of duty, or simply deliberate breach of duty. If the latter, then they refer only to a breach of duty which has been committed intentionally. The distinction is between intentional wrongdoing on the one hand and negligence or inadvertent wrongdoing on the other. So the contest was really, where does the word deliberate sit? Should it qualify the act or the breach? And as your lordships will be aware, they found it must qualify the breach. But what's interesting is if one goes to look at what the arguments were in relation to recklessness, and both parties had accepted that on the narrow construction, which the lordships opted for, in other words, it must be a deliberate breach, on the narrow construction, recklessness was excluded, and they all proceeded on that basis. And indeed, it's my submission that the court must have done likewise. And you can see that they both sets of counsel tried to turn that point to their advantage. So one sees this on behalf of the defendants at page 521. And at 521, my lords, you'll see at D, you have a summary of the argument of Mr. Davidson, QC, for the defendants. And he says at D, the 1980 Act, by not including recklessness amongst the categories of conducts giving rise to the extension of the limitation period by delaying its start, as the Law Reform Committee in its 21st report had proposed. So there he's saying they removed the word reckless from the Law Commission's proposal. And that's significant because it shows that recklessness was not covered. That makes it plain that Parliament cannot have intended to include conduct less reprehensible than reckless. So he says, well, if recklessness isn't covered, and it isn't, then negligence certainly isn't covered. So that's his point on recklessness. Mr. Doctor tries to turn the point against Mr. Davidson, and you see that on page 523. But again, on the hypothesis that on Mr. Davidson's argument, recklessness is not caught. And so at 523, Mr. Doctor for the claimant says at A, 4 lines down, on the defendant's argument, turning a blind eye is not caught by either 32.2 or 32.1b. Another reason not to give it that interpretation which would be a step backwards for Parliament. It's easier to prove that a defendant turned a blind eye than to prove that he knew he was in breach, and easier to draw the inference that a defendant was reckless as to whether his advice was right and so on, than to prove that he knew he was in breach of contract. And then at little d underneath, he says, there is no reason why Parliament should have wanted to allow the reckless wrongdoer to escape from the effects of Section 32. It's most implausible that was its intention. So they both proceed on the assumption that on the narrow construction, recklessness is not included. They both pray in aid of that. But what you then don't see in the judgment anywhere is any suggestion by their lordships that they, whilst they accept Mr. Davidson's argument, and it must be a deliberate breach of duty, in the sense we suggest is right, what you don't see is them then saying, oh, and by the way, we disagree that recklessness isn't caught. It would be caught, and that's an answer to Mr. Doctor's reservations on that point. So you can see that there was argument. If their lordships had taken the view that actually the common ground was wrong, recklessness was in fact included in that narrow construction, then they would have said so. And it's that then gives colour to the constant references throughout the report in Cave to the need to be aware that what you are doing is a breach of duty. My lords, I see it's 1 o'clock. I could continue with Cave for 2 minutes and finish it, or wait until...
I think we can wait until 2 o'clock. Thank you.
My lord, I'm grateful.